Good morning, everyone. Just some quick housekeeping first, if I may. We've all probably never used as much conferencing technology as we have this year, so you'll recognise that connection audioability can vary. So if connection does drop, just reconnect via the link again, and that should work. Your microphones should all be on mute, but for the avoidance of doubt, can you make sure that you are actually muted, please? We will be circulating a recording of this webinar, so you can listen to us again at your leisure, and we'll also circulate the slides too. We have over 250 people registered to listen today, so that shows you just how topical this subject is. We've already had quite a few questions, so we will try to get to as many of these as possible. If you do have a question though, please use the pop-up icon at the bottom. I am Joanne McIvor. I'm a partner within the property team at Edwin, and it is my very great pleasure to chair this webinar with you this morning. I am joined, as you might expect, by an excellent panel. Owen Nedden from Planning Experts Lichfields, and from Cluttons we have National Head of Valuation, Jonathan Rhodes, and Head of Asset Management, Matt Peake. So good morning to you all.
Morning.
Morning, Joe.
Morning.
Good morning. It's been a very busy summer for the government, not just for trying to control a pandemic, but for announcing the most radical overhaul of planning legislation that we've seen in decades. Part of Boris Johnson's build agenda is the change to the Use Classes Order. Now, there hasn't been any changes to it since 1987, so I think it's fair to say that change was needed because it struggled for a while now to make sense of the commercial property in what is the 21st century. The whole philosophy of these changes is to allow greater freedom and flexibility in the use of commercial premises. But like all changes, it opens debate, and governments don't always think through every issue, and there ends up being some unintended consequences simply because they're not at the coalface. But we, like you, are at the coalface, and so we're at the receiving end of these changes. I'd like to begin, if I may, with you, Owen. Would you mind kicking off and giving us an outline of what these changes actually are?
Yeah, absolutely. Joe, thank you. We'll spend a couple of minutes now then just skimming through exactly what's changed and what the changes are, and in planning terms what some of them might mean. We've got a few slides. If we could pop on to the first of those, while we sort of wait for that to click on. As you know, the changes are brand new of the Use Classes Order, and they probably represent the most fundamental change to the Use Classes Order that there has really ever been, or been since for a long time. They came into force on the 1st of September this year, so we've had them there now for 2 months. And the principal idea, as far as we understand it from central government, is to just give greater flexibility to how we use existing stock within high street and other areas and local community areas, supporting diversity and an adaptation, particularly important at the moment, but also, you know, going forward, taking sort of perhaps less control or taking control away from the local authorities and into the hands of the market and potentially the community. In short, we now will have 3 new use classes, which replace 2 of the existing ones. We have a Class E, Commercial, Business and Services, a Class F1, Learning and Non-Residential Institutions, and a Class F2 for local community uses. And then some of the leisure uses and some of the retail uses now fall between these uses and find themselves by themselves as sui generis. We can go to the next slide. We have a bit of a table format, which hopefully gives a nice breakdown of of the changes. And you can see, and I'll whip through this fairly quickly, but the A use classes, A1 to A5, now have disappeared. The majority of A1, all of A2 and all of A3 become use class E. The only exception there is small shops in local areas that aren't within a kilometre of existing small shop. That goes into F2, but I'll touch on that in a moment. A4 pubs and A5 takeaways, they come away and they now sit by themselves within sui generis. Within the B use classes, B1 offices, research and light industrial fall now into the use class E, whereas B2 and B8 industrial and storage remain as they were. And the C use class as well remains untouched. And then the D use classes, D1 and D2, all fall away and become quite a mixed bag. We see so the likes of clinics and health centres fall within use class E, alongside gyms and indoor recreation also within E. Schools, non-residential education, public libraries, law courts, etc. Now form the new F1, the learning and non-residential institutions use class. And then most of the D2s, or a number of D2s, come into the new community use, F2, that's sort of halls and meeting places for local communities, and also includes some indoor sport recreation and outdoor sports and recreations. And within F2, they're also joined by these small shops in local community areas. And then finally, the ones that didn't fit within any of these new use classes, such as cinemas, bingo halls, now form a part of the sui generis by themselves. So if we just move on to the next one, next slide there, we've got a breakdown of class E, which I've sort of already gone over, the commercial, business and services, but there's a long list in here, and what's important to note is that the use classes order actually starts to define these or give them their own recognition. So within class E, there's part A, part B, part C, so they start to subdivide within class E, and the same is true of class F1 and F2. If we go on to the next slide, we can see some of the breakdown for class F1 and F2 as well. As I say, the class F2 is perhaps an interesting one, a local community uses class. Presumably the idea here is for government creating a group of uses which they feel could be interchangeable within a local community area, depending on the needs and wants of that local community. And that will include a small shop of under 280 square meters, as long as it's at least a kilometre away from a similar shop. And so perhaps there's a little bit of interpretation required on that one, but you can kind of see where F2 is headed. Whether or not it's covered all the right things is another matter. And then if we just go on to the next slide, which is the last one for me as part of this introduction, and just sort of a little summary of the key planning implications. There's a couple of things just to be clear on, really. Now we have these new use classes, bandings, it's important to remember that a change within the use class is not development. No planning permission is required for it. You don't need a permitted development. The change isn't permitted development because it's not development. And therefore the movement between the use is in theory free. It will have, and it is having, implications on local plan policies, and we'll touch on that probably in debate and questions a little later. But local plan policies have often been all about controlling these kind of uses and how areas develop and how they're formed for the best, in principle, for the best use of the local area. This takes away some of the control that the planning policy would have and puts that into the hands of the market. The use of conditions will become more important. New planning permissions granted. It'd be interesting to see how local authorities perhaps seek to control movement within Class C or Class F1 or F2 by using conditions, and how legitimate that will be. But equally, as applicants on new applications, conditions might be quite useful. It might be that you want to limit the use here because otherwise your planning application might have to consider all the implications of every use class, every type of use within Class E. Some will have greater amenity impacts or greater transport impacts than the one thing you really might want, and therefore having restrictive conditions might actually be a benefit, and it's something to think carefully about. The current PD rights are unchanged, so office to resi, and the upward extension, for example, that were new this summer, they will still operate on the old use classes order. It's where it gets slightly confusing. For the period of time now, we'll have two use classes orders, the new one for new schemes and existing schemes. But if you're going to use PD, you have to look back at the old use classes order. And the government have given themselves until next summer to work out how they're going to integrate the two together. But for the time being, there's two regimes. SIL is one just to look out for. You know, within Class E, there's such a range of uses that local authority charging schedules may be that they have a charge for office, but they don't have a charge for retail. So an application just for Class E, it may be that local authorities seek to charge the highest rate of SIL that they possibly can. That would be potentially logical for them to do, and something to look out for, and might also be a reason to narrow the scope of the Class E that you want. But also perhaps I would encourage engagement with a local authority early, just to understand how they might be seeking to apply SIL in their area. Judicial review, it is up for judicial review at the moment. It's gone through the courts in October. We're waiting for the final decision there. It is in force at the moment. That could change, but you know, for the time being, we don't know, and so there's not a lot we can sort of say about that. If it is ultimately quashed, then the government will have to look at whether they want to reintroduce it and go through a different way of doing so, perhaps with greater consultation. And then finally, just to be aware of, while these new changes within the use class don't require permission, that assumes that there's no restrictions on the property as it exists. So everybody needs to be very mindful of the planning history of the site, you know, potential planning conditions that might restrict change of use of existing buildings, Section 1 obligation, Section 106 obligations, and any other legal restrictions or operations that might exist, and that's something for everyone to be aware of. And actually, perhaps it's a good time for me to hand over to Joe, who can perhaps offer a bit more insight on those points.
Yeah, thanks, Owen. Yeah, I think you're right. Before relying on any of these changes, the parties really do need to revisit their leases, wouldn't they? Just to, I suppose, ensure that they've actually got the record to look at these changes. So the first and foremost, landlords and tenants really do need to check that their leases don't have any nasty constraints imposed by way of restrictive covenants and user clauses. And you're right as well, it's the planning history of the property is really, really important, because it needs to be checked carefully just to make sure and to establish whether there are any pre-existing restrictive conditions or planning obligations that would restrict the operation of the property, or even operate to prevent further changes of use from taking place at all. That's the theory. These changes in theory do, I suppose, don't they, dispose of the need for freeholders and of tenants to go through the lengthy, expensive planning approval process to seek a change of use. So it's a bit of CPR, isn't it, into the high street, which was sorely needed. As I said, theory, but the practical consequences are really, really important. So I'd look to you, Matt. Can you offer any insight? What do you think these changes in practical terms are going to mean for the high street?
Thanks, Jo. Morning, everybody. The practical aspects of changes to the use classes order is that high streets in towns and cities up and down the country have been struggling now for some time, and COVID has just accelerated this issue. An oversupply of shops coupled with fewer shoppers, as more and more of us buy online, has led to increasing vacancy rates right across the UK. I read recently that the overall vacancy rate on high streets in the UK reached a record 13.3% last quarter, up from just over 12% in Q2. In fact, the Times newspaper this morning reports that the number of shops and restaurants closing more than doubled in the first half of this year compared to the same period last year. So it makes sense, therefore, for owners to be able to switch buildings from an obsolete function, for example, a bank or a department store into one that attracts customers, for example, a cafe or even a bowling alley, without the need for planning permission. So the new Class E should make it easier for landlords to rent out vacant shops and other buildings by attracting a much wider range of potential tenants. It could also offer up the possibility of multiple occupiers in one building, as different businesses use space at the same time or different times of the day. For example, a property could operate as a shop during the day and a restaurant or a gym in the evening. A precursor to these proposed changes was the government's Project Speed infrastructure plan, which was launched in June of this year. This included a commitment for more types of commercial properties to have total flexibility to be repurposed and to provide greater freedom for buildings in our town centres to change use without planning permission. So the reforms are designed really to introduce greater flexibility as to how a building is used depending on demand, and by allowing a greater mix and variety of tenants, this should really bring town centres back to life and fill vacancies. And this increased competition for space, particularly in areas of high demand, should in theory drive up rental values, and landlords might be able then to pick and choose the most valuable use for their property.
Yeah, so it's wider choice of use. I suppose it's going to introduce a broader range of occupiers, potentially, as you say, multiple occupiers offering a wide range of uses. What's interesting though about that, isn't it, is how that's going to manifest itself with local authorities. Ona, how do you think that local authorities will deal with the policy implications of all of this?
Yeah, it's an interesting question, because obviously traditionally policy is often been drafted for high streets and district centres and other sort of important centres to be fairly restrictive about the types of uses that can go in there. And this does change things, particularly for existing high streets with existing properties that now should, in theory, subject to conditions, have the flexibility to move within lots more uses that previously policy would have resisted without strong justification and evidence. We've all seen policies sort of drafted for high street locations that limit the number of non-A1 uses within a parade, or every 4 shops, and so on and so forth. And some of them are quite complicated. In existing high street locations now, as long as there's no restricted conditions, the owners operators in theory can just move between a much broader range, and it does leave that policy rather toothless. I think for new schemes coming forward, the policy would probably still be in a position to hold some weight, and maybe it needs to adapt slightly, but the likes of Class E being subdivided into A, B, C, D, retail and food and beverage and business and offices, still allows a local authority to subdivide and retain some control. But certainly for existing premises, that ability to control, because it doesn't have to come back into planning, is certainly diluted. And as Matt mentioned there, how that might sort of start to affect how the market looks at it, and perhaps the high street values is of interest. And I wonder, Jonathan, it's probably your sort of area. You might be able to add a little bit of insight there to how you think the high street values might be affected.
Yeah, thanks, Owen. Morning, everybody. As Matt's alluded to, the retail market, sort of even before the pandemic, was already going through a bit of a sea change, and obviously the pandemic has just precipitated that to a certain extent. Therefore, valuing retail premises even before the pandemic was beginning to prove a little bit problematical, but obviously that has very much increased tension. I suppose it's worth saying that capital values have decreased substantially during the course of this year within the retail environment, and ultimately that's a combination of factors, but largely down to the fact that many tenants, particularly multiple retailers, are using CVAs as a way to reduce or limit their exposure to unwanted retail premises. And certainly their demand for turnover rents is seeking to effectively unbalance the relationship that ought to exist between both property owners and occupiers as tenants. Ultimately, for owners of premises, the next 12 to 18 months is probably going to be more focused upon keeping premises let and income producing. Income returns are going to be the main focus for them. They also, therefore, in order to be able to achieve that, need to embrace these changes in the form of seeking to benefit from the wide range of potential uses within Class E, and therefore to seek to keep their premises let and income producing. However, as Owen's alluded to, local authorities, have in the past used policies to restrict types of uses within prime high street locations, for example. Certainly A3 uses were often quite limited in terms of how many of those units could be let within a certain number of units, and that may be something that comes to fore here. But I suppose the big question is will the new Class E within a town centre, city centre, high street environment increase competition for space? Therefore, will in fact rental levels stop their current sort of subsidence, and therefore level out and potentially therefore increase in the medium longer term? Certainly, obviously, we've seen over the last 10 years in particular, the whole concept of dwell time for retail environments has increased. And that's largely been through the embracing aspect of bringing together retail and leisure uses in particular. So the question therefore is whether this change is actually going to bring to the fore more community type uses, a wider range of uses, which ultimately fit better together, and therefore create an environment which is more customer focused. Certainly during the pandemic, we've seen local parades, neighbourhood parades actually benefiting from the pandemic, because local communities have wanted to use those facilities more. And in fact, therefore, those sorts of premises have actually proven to be a slightly more sustainable model. Certainly local parades probably have quite a wide range of uses, and certainly there's often residential above. So I suppose bringing residential back into town centres, which has been spoken about for some time, but hasn't really been actioned, may be something that therefore, in conjunction with these changes within the used classes order and Class E, needs to be considered more proactively and encouraged by local authorities to happen, because in that way you can create that sense of community. I suppose therefore, Matt, from that point of view, this whole concept of community hubs, community uses, do you think that's going to benefit the smaller sort of centres within the retail environment, and particularly perhaps market towns?
Thanks, Jonathan. Yes, I would tend to agree. I mean, it's been widely reported that businesses in suburban towns and villages are reporting increased trade as a result of more people having working from home and buying their daily flat white, for example, at their local coffee shop. The Times newspaper, again this morning, other newspapers are available, reports that independent businesses, which account for over 60% of the retail and leisure market, have actually fared much better than chains when looking at shop and restaurant closures over the last 6 months or so, accounting for a little less than a third of all vacancies. So perhaps then this is indicative of more people shopping in their local communities. So the proposed reforms may well accelerate this trend as remote working becomes more established for many office-based workers once the pandemic has passed. These reforms in the main are about allowing buildings to evolve and develop as consumer requirements change, as new trends emerge and business needs adjust. The new Class E reform should therefore ensure that buildings can be multi-purposed over time and are therefore relevant for longer. Anecdotally, a couple of our managed clients hold offices in Richmond in southwest London in their portfolios. We don't have any vacancies in these multi-let buildings at present, but local letting agents report that the number of inquiries has never been greater from businesses wanting a small amount of space for locally based employees. equally, in my local village, a former estate agent has been converted into a business centre, offering desk space on a daily basis. An organic coffee shop has popped up next door, interestingly. However, it's important to understand, I think, exactly what people want from their town centres. Visitors don't just go there to shop nowadays. They want more of a customer experience, whether that be eating out, going to the cinema, attending an event, or other forms of entertainment. I have a teenage daughter, and she goes to our local town to socialise and to meet friends. Shopping may or may not play a part in this. Often she may collect or return clothes bought online. It's worth pointing out also, I think, at this stage, as Owen has touched on, that the new use class F2 has been introduced to protect community use assets through the planning system. So these might be village halls, swimming baths, or small shops in rural communities, as Owen has said, all designated as places to meet and socialise. The principle here is to allow flexibility of use for local communities. So, for example, an indoor swimming pool could be changed into a skating rink if there is greater community need for this particular use. Jonathan, how do you think these changes then might influence more urban regeneration and perhaps the use of CPO powers?
Thanks, Matt. Ownership within city centres is fragmented. It's not owned by big institutional funds or big property companies these days. They tend to own sort of shopping centres and the larger scale assets. It's private investors that tend to own unit shops. So you've got a very sort of disjointed structure there, which therefore prevents urban regeneration happening. It's only through the use of CPO powers ultimately that has enabled some town centres to be regenerated. Councils obviously are very keen to embrace inward investment into their locations, and I think we may well see that these changes almost sort of encourage councils through the use of CPO. But I think one important consideration has been made here, given the economic impact of the pandemic, which is going to be sort of long felt, is the need for public sector, private sector partnerships to come to the fore. And without public sector purse, and particularly without the Public Works Loan Board, for example, putting in money into this, so rather than local authorities going out seeking spurious investments to help sort of plug their income gap, they should in fact be seeking to jointly invest alongside the private sector in terms of urban regeneration. Certainly, Matt, as you said earlier, given the current vacancy rate that currently exists within the retail environment at 13% plus and growing, we need to avoid town centre degradation. And without, therefore, local authority, public sector involvement in those projects, we will see town centres deteriorate and therefore become almost ghost town type environments. So local authorities do have a duty, and I think therefore ought to be seeking to proactively look at their urban centres and seek to utilise the access to cheap money that they have to prime these opportunities, to therefore jointly work with the private sector who can bring a commercial dynamic to regeneration to the fore, and therefore, as I say, bringing inward investment to change the dynamics of local communities. Joe, I suppose sort of we've talked about town centres to a certain extent a lot. I think it's probably worth us sort of looking out of town centres as to how these changes may influence that sector as well.
Yeah, out of town. We can't forget those businesses that are out of town, the business parks, the industrial estates, and the retail parks, which are obviously going to be the face of change here as well. I think, Owen, you'll probably be the best person to answer this one. How far do you think the policy, the local authorities are going to go with dealing with these changes? presumably it will be far-reaching implications for plan making.
Yeah, again, it's an interesting one for local authorities here, because much like the high street, the out of centre uses has always carried with it a high degree of protection, and laid down in national policy for main town centre uses outside of town centres, and the requirement for sequential tests to establish that it's acceptable to do it and it won't harm the local centre. The changes here do change that, the approach to that very significantly. Existing premises, again, if not subject to restrictive conditions and obligations, for them to now change between uses and change to other uses that perhaps previously under a sequential test might not have been acceptable, if they're in the same use class E, for example, then you don't have to go back to the local authority to establish that change of use. It's a given, and therefore, the ability for the local authority to change to control that is gone, and the ability for them to control the impact that it might have been perceived that would have on the centre, the local centre that they were trying to protect, has gone. And so I think for new applications, applications for out of town centres, the local authority will still likely be able to apply control, apply a form of the sequential test, albeit a different one, given how now the use classes allow high streets and town centres to adapt, and the flexibility within what you could put in an out of town location. So it's a changed approach, but for new applications, the sequential approach would still be there. But it's for existing where that's kind of stripped away. Now, you might need planning permission for external alterations to make it work within its new use, but the degree to which a local authority could use that to try and control the change of use, we think should be fairly limited. They shouldn't be able to intervene in the change of use just because you need to change the external appearance of the building or add windows. That should be based on its own merits, with the change of use a given. So, in theory, on existing business parks, it should be possible to change units from offices to gyms or to day nurseries, and equally on retail parks, it should be possible to change retail units over to offices. Of course, if the demand is there, if the need is there, and if the market suggests that that's the right thing to do in that location. And I guess the question really there is one perhaps to Matt to elaborate on, is that how will the out of town asset managers view these changes? Are there plenty of opportunities there within these out of town centres and locations to start utilising this flexibility?
Yeah, I think so, Owen. I mean, I think as a result of these changes, certainly retail and shopping parks will be able to integrate a greater mix of uses into the scheme. It may polarise parks more. We may see the best retail parks wanting to increase their amenity offer and dwell time to attract and retain shoppers. And the reforms could help more secondary schemes, tertiary schemes, for example, to increase footfall or to transition to another commercial use entirely, as you say, to offices, for example. Existing out-of-town office locations and business parks will be able to incorporate health clubs, retail uses, and even a day nursery or creche, for example, if the owners believe that these facilities will attract and retain occupiers. Now, whether this accelerates the much talked about hub and spoke model, where a business has a centralized HQ hub with a network of smaller regional offices or spokes, remains to be seen, as indeed does the future of the traditional business park as we know it, which has fallen out of favour recently with both occupiers and investors, but may experience a bit of a renaissance in the wake of the pandemic as office workers seek to avoid public transport and city centres and drive to work. There should also be, I would imagine, increased flexibility for lighter industrial and R&D, research and development uses, those within the old Class B1, whereby we might see more discount food retailers, for example, occupying redundant office buildings, especially in suburban and edge of town locations. In reality, though, the industrial sector has been performing quite well of late, with relatively strong growth prospects. So landlords may actually find a change of use is financially unviable.
Yeah, Matt, sort of, just picking up on that, obviously from a valuation point of view, you mentioned the word unviable. Plainly, some of these changes may require capex, and therefore, balanced against therefore whatever rent they can demand for those premises is obviously going to influence asset management decisions as to how they may seek to blend uses more. I think, however, it's worth saying, as you said, within the retail environment, we've seen the whole concept of mixing of uses and dwell time come to the fore in the last 10 years. And business parks, as you say, need to evolve. They have fallen out of favour. The way they can evolve, therefore, is to embrace this whole opportunity, ultimately, that Class E offers, to ensure, therefore, that you create the community hubs that perhaps people want. Certainly, I've heard that there's been a suggestion that the service office sector in particular may well benefit from the pandemic as people seek to create those hubs to offer greater flexible, localized working environments that people can therefore drop into from their home far more easily, while having to commute longer distances. So bringing in things like nurseries, gyms, etc. into those environments ought to, in my opinion, over the medium longer term, actually benefit those assets because they make them more attractive to a wider range of occupiers, and therefore ultimately ought to be driving up rental growth levels as demand increases because people want to be located in those sorts of environments. I think we've spoken a lot this morning about community, and the pandemic's obviously brought that into the fore, but I think the government's policy here is very much following that trend that's been invoked by the pandemic. So, change, I think, certainly ought to be coming for business parks as a consequence of these changes, and therefore that ought to have a positive impact, subject to, as you say, the viability question and capex. Retail parks, personally, I can see that having less of an impact here, but plainly, the more secondary, tertiary ones where they're struggling in terms of retail occupiers may well have the opportunity to be able to embrace this as well. Within the industrial environment, we've seen trade parks or trade park type units become far more of interest to investors over the last few years because they offer a cheaper form of quasi-retail, and therefore from a rental point of view, they're actually quite low in comparison to traditional retail parks. And therefore it may well be that these changes enable both landlords and tenants to embrace that change, and therefore we may well see a greater amount of trade counter types units being created on industrial estates. However, as Owen has alluded to, it could well be that local councils and planning policies change to limit the impact of this in a beneficial way, and therefore what everyone sees as being the opportunity may in fact be impeded by the way that local authorities seek to challenge this change of uses. Joe, I think in terms of therefore what we've spoken about here in terms of various sectors, I think there's obviously an area that this impacts quite succinctly in terms of property investment in particular, and that's leases. Do you want to touch on as to how we see, or you see, sorry, the changes impacting both existing but also future leases?
Yeah, sure. It's a topic of debate, and there's obviously some different schools of thought. Do landowners and institutional investors, for example, want to maintain control by introducing more restrictive use classes in their leases, or should they embrace the flexibility that's provided by the Class E to ensure lower vacancy rates, as the nature shopping and of working practices responds to COVID, because life has changed and it's going to continue to. At this stage, in terms of drafting, and I'll just touch on this briefly, it's a bit dry, the different approaches would be, I suppose, either using generic language without specific reference to use class orders, so for example, a use as a restaurant, or referring to a limited list of alternative uses, so for example, permitted with consent, and excluded uses, and or changes of use, still using though the generic language without specific reference to use class orders. In my view, I think personally it's unlikely that there's going to be reference to use class E. Why? I think tenants, yes, of course, they're going to welcome the flexibility of an open E-class use, but the uses within the class are so wide that landlords are going to, I think, require more control. Leases, I think, may continue to refer to specific uses, and references to use classes may actually disappear altogether, especially in town centre settings. I think really this is the time for landlords to think very carefully about what range of uses and flexibility that they're going to permit in their leases going forward, and that's going to be based on their actual intentions for the property and what their wider placemaking strategy is. And you know, it's exciting, it's interesting times, because part of that strategy for landlords, I think, is going to be the big picture, isn't it, for what the investment purposes are. So how do you value, for example, you know, what's the impact of rent review? For example, let's not forget that, you know, retail tenants can't afford the ever increasing upward only rent review that's been imposed for years and years by landlords, as we all know. And is that problem going to be solved by a change in use class? You know, a lease that doesn't contain a restrictive permitted user clause, and where the tenant can take advantage of the wider use class E might mean that the tenant might be required to pay more rent on a rent review, since it's now, you know, it will now be open to the landlord at the time of review to claim that, well, you know, the tenant can use the premises for any use within use class E. So arguably, you know, all the landlord has to do really is find any other premises that are paying a higher rent that's been used for that purpose within use class E in the area, and use those premises as a comparable when negotiating its tenant's new rent. Now, I am obviously not an expert in valuation and rent review valuations, but you are, Jonathan. So what's your view on that? Now, and I do think this is quite a big topic, because we have seen that we've got quite a few questions on that's coming through. So no pressure, but over to you.
Thank you, Chair. You know, you're right that the existing user clause in the lease is obviously the starting point in terms of assessing the rent upon review. However, the extent to which that offers flexibility in terms of the reasonableness test, for example, will also come into play. However, I think one thing that landlords may have to battle with here is subletting, whereby if a tenant can turn around and say, under Class E, I could in theory sublet this to another type of occupier, a non-retail occupier, but at a rent that's equal to the passing rent or potentially higher than the passing rent, will a landlord actually, because it's outside of the existing user clause, say no? Plainly, however, if the landlord were to say yes, because in the longer term it may in fact benefit their investment, that therefore it may sort of through the process of time be proven actually that the new Class E provides that flexibility, even though the user clause doesn't in theory. And plainly as a result of that, that will have an impact upon review. So I think landlords are going to be faced with a bit of a conundrum here to a certain extent, is that they will have the reasonableness test under subletting to accept a rent that's equal to passing, if not potentially higher, but outside the user clause, as to then what that means in terms of rent reviews. So, obviously time will tell. This is all very new. No transactions have yet happened, and in fact, the market is obviously to a certain extent in abeyance at the moment, given the pandemic. However, I can see zoning, for example, of retail premises becoming a bit of a non-entity in the future when Class E embraces this wide range of uses, and the basis upon which rent is assessed becomes based upon the total net internal area, for example, as opposed to traditional zoning of retail premises. So I think the whole approach potentially to valuing high street retail premises will change over time because of different types of occupiers seeking to bid for former retail premises in a different way, and therefore zoning as a analysis tool, method of valuation may well become a thing of the past. I think it's also just worth saying that tenants ought to be aware, however, that this change of Class E may in fact also impact upon their ability to defend dilapidation claims, because as an expert of Section 18 valuations, I know that the principle of a premises not even being able to be let in a good repair is often used as an argument to defend a dilapse claim. However, within Class E, of course, because you're offering a far wider range of users who may seek to occupy that space, that principle of a defence against a claim is likely to be watered down. So I think there's a benefit here to landlords in terms of potentially increased rental levels in years to come, but equally for tenants, there's a downside in terms of their ability to defend collapse claims.
Well, I'm conscious, thank you so much, Jonathan. I'm conscious of time. I said at the beginning of this seminar that obviously change provokes debate and conversation. And I think it has been actually really, really interesting to explore the different views and opinions that we've got and the implications that this may have, both good and bad. And I think it's a general summary of it. The positives of what we can see is, well, yes, it's the flexibility of use, isn't it? It's the potential to increase rental values. It's town centre regeneration. It's the positive implications for out of town. And then offset against that is the balancing act. It's like there are obviously going to be some negative implications of it. And that comes to perhaps councils, local authorities, planning and strategic policies, the increased use perhaps of compulsory purchase. Matt touched on as well the estate management issues and what the tenant mix of that is going to be. And Jonathan, what you've finally just mentioned is, yes, it's dilapidation issues and the user classes and what implication that's going to have to landlords and tenants with their rent review. In a time, I suppose, when we've all had to embrace change, let's hope, though, that the response is by and large positive, where we create a greater diversity of uses where they are missing, and at the same time allowing flexibility where it's needed, which really together it's all for the benefit of the wider economy. We will all benefit. I'm going to open it up now to some questions which have been coming in fast and furiously. So apologies in advance if we don't get to all of them. We'll try and get back to you perhaps on an individual basis in the next coming days, because there really are tens and tens of them coming through. One of them is from Paul in Mayfair, who asks, what are the implications for landlords, property owners and occupier tenants of premises which are now designated as sui generis under the new use classes order and which were previously in a wider use class?
Well, it's an interesting one. I think conscious of time, so I'll be brief as possible, but I think what we have here is a number of uses obviously seen by central government either to fall between the gaps of the new use classes that were created, or were deserving of being taken out of the use class, either to protect amenity or to protect them as individual uses from being merged in with others and allowing the change between them. But in short, by being sui generis now, there is no change to another use allowable that isn't considered development, and therefore planning permission is required for all changes. And then you have to move back to the policy position for that particular type of use, and it will depend where the local plan is in terms of distinguishing those particular uses. If it's a pub, you know, a lot of local plans now do deal with pubs and do have specific policies on them, on the requirement for marketing, etc. If they are going to be lost. In other cases, like cinemas, bingo halls, for example, I'm not aware of many bingo halls in Mayfair, but they probably don't have as much policy around the control of them and how a local authority might deal with them, and so it's a bit more up in the air as to how local authorities are going to receive permissions for them. And again, I think engagement with the local authority on those points is going to be very important.
Yeah.
I think also, Owen, just from a valuation point of view, it creates more uncertainty being within the sui generis use, because you've got to have to go through the planning system, be able to seek to get a change to another use, or etc. So I think in all likelihood there's going to be less hope value associated with those uses potentially that sit within the sui generis use, because of potential time delays, increased cost in terms of plan applications, etc., may therefore result in schemes be less viable.
My take on it is that the reference to pubs, for example, that Owen made, is as much about affording them protection from change of use to prevent the loss of a community facility, for example, our local boozer, as it is to prevent a proliferation of noisy and unpleasant smelling uses such as pubs, live music venues, hot food takeaways, etc., on our high streets and town centres.
Thank you. We have another question from Dave in Coventry, who asks, what effect will the new rights conferred in new use class E have on properties in a conservation area? Owen, do you want to talk about that first?
Yeah, well, I mean, the change within the use classes isn't development, so the conservation area has no implications for the change between the uses. The conservation area would come into play in terms of any external alterations. The conservation area is a designated heritage asset, and therefore any external works that would require planning permission would need to have regard for ensuring that they didn't unduly harm the heritage asset, the conservation area. So then it becomes a classic planning and play and an application required, and a degree of sensitivity about the design and understanding the local context. But from a change of use within the use classes order, well, it wouldn't be a change of use because it's not development. So the conservation area doesn't have implications for that.
Okay, we have another question. Oh, did you want to add anything?
No, it's all right. Go for it, Joe. It's fine.
We have another question from Samantha in Richmond. Will previous planning conditions on a property preventing alternative uses have any effect like they did for PDR? And would councils be able to use Article 4 directions? No, don't believe they can use Article 4 directions. Article 4 directions are there to prevent the use of permitted development rights, which allow for deemed consent to move between uses. Because this is not development, then there's no PD for either. The change within them wouldn't be able to be controlled by Article 4, as far as I'd be aware. Conditions, yes, it's one of the big things to look for. There is an opportunity for conditions on existing planning permissions attached to properties to control your ability to move within a use class, depending on the specifics of the wording, much in the same way as it's been found for PD rights. Whether or not the condition is worded in such a way to give that protection is down to the specifics of the language used.
and is quite a technical planning law a question, and needs to be sort of considered on the individual merits of the wording. But it is something to certainly look out for.
Yeah, certainly from my point of view, I think, as I said earlier, I'd like to see local planning authorities really embrace these changes, rather than seeking to adopt protectionist policies for whatever reason. In order to encourage, as I said earlier, regeneration, and particularly town centre regeneration, I'd like to take them sort of to challenge local authorities to take a more proactive stance in this regard, rather than actually always seeking to work off the back foot and sort of not embrace change. From a valuation point of view, obviously embracing these changes ought to have a positive impact in the medium longer term. And I think, given, dare I say it, sort of Brexit as well as the pandemic, the UK will need to adapt for the future, and these changes are part of that process. And hopefully, will therefore encourage greater inward investment into property across the spectrum, which ultimately will benefit everybody and also communities.
Yeah, I think that collaboration point is quite an important one. Engaging the local authorities as best you can, certainly help with larger site assembly, and they may help with wider collaboration between stakeholders and coordinating schemes. And as Jonathan said, what this could do on our high streets is create joint ventures and partnerships between private sector landlords and private and public sector landlords to unlock parades or blocks of property held in multiple ownerships. And you might even see landlords working closer with tenants and then users to repurpose difficult or inflexible buildings, for example, department stores. So I think collaboration and trying to bring the local authority on board will be key to transforming the high streets in the way that it's predicted that they may be.
Yeah. Well, I think that's a really positive place to end, actually. We are, I think, the four of us are collectively sponsors of Positivity United, shall we say? So, yes, let's go on a positive spin to these changes. I'm afraid that is all we have time for this morning. It's been a quick hour. Thank you to the panel. It's been fantastic this morning. Thank you very much. And thank you to you all for taking the time out of your day to listen to us. A final request, if we may, before you all go, would you be so kind to complete the survey just before you leave this webinar? I think it's safe to say that this is now the means of communicating for the foreseeable. So we'd love to hear what you think, what you would like to hear, and what perhaps we could do better. So yes, we would love to hear your feedback. In the meantime, thank you once again and have a great day.
Thank you.